You know, our system of justice is based on this model of the adversarial system of justice, which is where you have two people who have a dispute. They bring it into court. One brings in their evidence to present to the judge and to criticize the other person's evidence, and the other person does the same. At the end of the trial, the judge declares a winner, and both sides go off in their own little happy life. That really isn't the way it is with domestic relations cases, because these people, when we are through with our hearing, are not through with each other.
There's nothing more frustrating to me as a judge than to have two parties. It's a he said, she said most of the time. And a lot of times, unfortunately, I think because of the economy, parents don't have lawyers. They don't know how to conduct themselves in court. It's a lot of hearsay information. It's a lot of evidence that is really not admissible, and it goes back and forth. It can sometimes turn into a circus. Makes it really difficult for a judge to be able to gather the kind of information that we need.
A dear friend, one of my judges, came to me, I think it was in 2007, to tell me she was really jazzed up and she wanted to tell me about a program that she had heard about in Minnesota that was an alternative to the more adversarial nature of handling divorce cases, and it was called Early Neutral Evaluation. In Colorado, we call it Early Neutral Assessment. And it was interesting because when she started to talk with me about the program itself, I just started to remember my years as a judicial educator and hearing judges talk about how their least favorite assignment was going to be domestic. Domestic relations and divorce in general is expensive. It's time-consuming. It's become so adversarial as part of our traditional legal system. And most importantly, it's psychologically damaging to families and to children. And I think the judges rotating into domestic realize that and get frustrated.
One of the important aspects, I think, of the E&A is to deal with this in an early basis. That's why it's called early neutral assessment. And we do that because the longer that we wait to intervene, the more encamped these people get. I think we have to understand that we're dealing with these people at probably the worst time of their life. They're mad, they're scared, they're suspicious, and the longer that we go on, the more suspicions there are between the two of them, and the harder it is for them to deal with one another in making decisions.
Before referring parties to an E&A session, there is a screening process that I use to make sure that the case is appropriate for E&A. Cases that would not be referred to an E&A session would include cases where there is an extreme cases of domestic violence, sex abuse, cases where criminal actions are still pending.
The magistrate or the judge in the 17th Judicial District goes and speaks to the parties before the process starts. We call it a pitch.
What I do during the pitch, first of all, I let them know and see them in my presence, in my robes, and let them know that the courts back what these people are doing as the E&A, that it's our desire, not just the E&A people, but it's our desire as a court to assist these people in arriving at their own decision. I try to tell them the value of it. When I go in there, I make certain that I know who the kids are and what their names are and what their ages are. One of the first things that I always do is I ask for pictures of them because I want them to know that I really am interested in the welfare of their children.
The early and neutral assessment team is composed of a male and a female. I think that just helps the parties obviously feel more comfortable. And I think the idea by having a male and a female is that you get both genders, both sides feel like their perspective is being heard.
One of them can know the ins and outs of the legal system in case there are questions about the legality of something or whether or not something can be modified or how you modify that. Although we don't give them legal advice as to how to file motions, we can let them know generally that this isn't set in stone, and if there are issues that you can't resolve and can't stipulate, that there are ways that you can come into court. And we have a psychologist or somebody who's trained in counseling who can understand, I suppose, and work too. The concerns that people have, the fear that people have, the pain that people have, because those are obstacles we have to deal with in talking with one another, and it's the obstacles that these two people are going to have to deal with one another in talking to each other.
So it's voluntary, it's parent-driven, we hear directly from the parents, it's confidential, it's less costly, both financially and emotionally, we believe.
And it's educational. It helps the parents understand what's happening with their kids. Sue, as the mental health professional, brings out a lot of research, a lot of things about child development, about attachment theory, things of this nature that are very important for parents to hear, to consider. For many parents, that's the first time they've ever thought about how their child develops and how that may relate to parenting time schedules.
And then what we do is we come, after we've heard from each of them and their attorneys if they're represented, we come back with what we think is likely to occur. So we give them a realistic expectation if they were to go to a hearing or go to an evaluation or that kind of thing. And then we think they're better able to negotiate if they're negotiating from a place of being realistic.
I'd like to talk about how I've seen families come in with 2, sometimes 3 or 4 children. They've come into the court with attorneys or without attorneys. They've filled out their paperwork, and in 3 to 4 hours, they have reached a complete parenting plan regarding their children. They've resolved all of their disputes about holiday parenting time, all of their parenting time disputes. They've gone before the magistrate or the judge that same day, and they've walked out of this court with a permanent order.
The advantage that the ENA process has is it really gives the power to the family, that they come out with an agreement that they've agreed on, that they've worked together on, and they can present to their children as their agreement and not something forced upon them by a judicial officer or compromised due to the fact that they weren't able to get out all the information and all the pieces that they thought were important. Not only is it good for the litigants and their children, but for the other members of the family and the other support systems that the litigants have. Because oftentimes coming out of a contested hearing, the parties often say, well, if I had said this, it would have come out differently, or if I was able to present more information, it may have been different. But coming out with an agreement that they agreed on is that they can then come to their support system and say, no, this is good. This is good for our family because it was our decision. We decided. We didn't let anybody else make the decisions for us, but we made our decisions ourselves. The evidence will show that the modification level is much less in a situation where parties have come up with the agreement themselves rather than believing that they could come back and add a little more information and change the outcome.
Are we glad that we did this pilot program in the 17th? Absolutely. I'm going to suggest that it has worked even better than our early hopes had anticipated. And I support it 110% and highly recommend to any jurisdiction in the state of Colorado and any state in the United States to take a long, hard look at this program because, ladies and gentlemen, it works. And it's good for the client and the customer.